Hi, I really hope you enjoy this educational video. My name is Mark Byelich. I'm a certified financial planner, and my team and I focus on developing tax efficient or tax free retirement strategies for our clients. We also focus on investment strategies that allow folks to eliminate the worry and have the potential growth that you need in retirement. So enjoy the video, and at the end, I'll tell you how you can schedule a no cost, no obligation consultation with me. Enjoy. All right. Well, hey everybody, it's 6:30. It's 6:30 on Wednesday, and this is our second in our advanced class series. And I want to thank everybody for joining us. We've got a special guest tonight. I think you all probably know Bryan Adler at this point. He's
Good evening,
joined
everybody.
us. He's joined us a few times. Bryan's an extraordinary estate attorney and elder law attorney. And I'm going to give you a little bit of a bio of Bryan's in a second, but I just want to remind you that everybody is muted. There is a Q&A at the bottom of your toolbar, your Zoom toolbar, and we encourage you to use it. So as we go, if you have questions, just type away. I'll try to pay attention while we're talking, but we'll take a break and see what questions there are, and we'll go through and answer them. Your chat, however, is disabled. It's some crazy regulatory requirement that I can't quite explain, but we have to follow the regulations, disable the chat. And of course, this video is recorded. So you often hear me talk about your team. So your team should be, in my opinion, a qualified certified financial planner, at least one attorney, and depending on the type of help you need, and often, almost always, it's an estate attorney and an elder law attorney. And I almost always recommend that, an estate attorney, elder law attorney, because even if you don't consider yourself elderly, often you have parents who you may have to be taken care of at some point, or it's always just a good idea to plan for yourself, because if you're 65, you've got some time to have a relationship with an individual like Bryan, who does estate planning and elder law and focuses on elder law. It's a specialization, because you don't want somebody who also does. So, if your brother-in-law is an attorney and he's a personal injury attorney, but he'll also help you with your elder law issues, it's probably not the best person to handle it as much as, you might care for your brother-in-law. You want somebody who specializes, because this is a very, very specialized field. So let me introduce Bryan. Bryan Adler is a certified elder law attorney through the National Elder Law Foundation, the only American Bar Association accredited certification in elder law. He dedicates his elder law practice to advising and counseling clients in the areas of elder law, life planning, asset protection, veterans benefits, estate planning, guardianships, and long-term care advocacy for both Pennsylvania and New Jersey residents. So in our continuing world of education, or changing world of education classes, goodness gracious, changing world of retirement education classes, we spend about an hour talking about estate planning, and we talk about the basics. We talk about wills. I give you a very brief overview of different types of trusts, and primarily revocable trusts and irrevocable trusts. And we talk about beneficiary designations and TODs, and which is transfer on death, and PODs, which is payable on death. And that's all very basic stuff. And tonight we're going to dig into some more advanced techniques. So I'm going to let Bryan say hello, and then he's really going to run with it. And then I'll answer questions, or ask questions as we go, and answer questions as we go.
Yeah, that's great.
Bryan, say hello again. And I know you have a PowerPoint, right, Bryan?
I'll bring it up after. I'll do a quick introduction, and I'll bring it up for sure so everyone can follow along. And but thank you, Mark. It's a great introduction. Again, I'm Bryan Adler. Thank you for introducing us. Tonight, I want to focus on, we are going to do a very brief basic document review, just so everyone kind of has the foundation, but I don't want to spend more than a minute or two on it. So we have a lot of unique and some would say even aggressive strategies that we're going to discuss tonight. So we're going to get into that. I look forward to answering questions, and I encourage everybody to participate. Now I'm going to start my screen share, and I'll bring up that PowerPoint.
So while Bryan's setting that up, I just want to look for if you could raise your hand if you're hearing us okay and seeing us okay. That just helps us. That's great.
And Mark, can you see that the title slide?
I sure can. So everybody should also see a PowerPoint slide in front of you. So just let us know.
So let's talk about the basic documents. And again, I'm certainly happy to answer questions. I don't want to dwell too much on these topics as we do have limited time and want to dive a little bit deeper. But we're going to go through what I recommend to be the 3/4 basic documents. So the first one is your last will and testament. In its most basic form, it's a document that says, I'm Bryan Adler. I own stuff. Here's where it goes when I die. Here is also the person I designate to carry out my wishes. That's its most basic form. Now, a will, it's very important, only distributes probate assets. And Mark previously just mentioned TOD, POD, and similar trust planning. Anything that has a joint owner, anything that has a beneficiary designation passes outside of the will. So what that means is if you prepared a will that leaves everything to me, but you make Mark your beneficiary on everything, I lose out. So that's an important part of the planning there, to make sure that your beneficiary designations and your will tie together or otherwise comply with your wishes. Next, we have our general financial or general durable power of attorney. That's the document that authorizes another person called your agent to make personal financial decisions on your behalf. A simple one might be paying your bills, buying and selling a house, making gifts of assets, restructuring funds for you, essentially standing in your shoes if you can't do something for yourself. And that's important given that the vast majority of the need for the power of attorney is when somebody's suffering from some sort of cognitive impairment or some other disability that prevents them from managing their own affairs. We also have the power of attorney for healthcare. Similar to the general power of attorney, the durable power of attorney, this is a similar concept, but it applies to healthcare, medical decisions, health insurance, privacy-related issues, and end-of-life decision-making, such that you would find an advance directive. My practice now, I include my healthcare power of attorney and my advance directive in one document. It's for ease of reference and to make sure we have one person appointed to make the decisions, both while you're alive and getting better, while you're alive and need care, but also when you're in that end-of-life situation and you want to instruct your agent on how to make decisions for extraordinary measures like artificial respiration, hydration, and nutrition. So those are the 4 basic documents. If you don't have those, get them. Everything else we're talking about tonight, if you came to me and said, hey, I want a family limited partnership, or I want to do a CRUT or a CRAT or an ILET, I'd say, let me see your will and powers of attorney. If you say I don't have them, I'd say do them first. So everybody needs to get them. If you don't have them, talk to Mark, talk to me. We can take care of it. But today is all about how to plan for a more complicated estate, how to plan creatively, how to take advantage of things to reduce taxes, how to take advantage of things to protect resources, perhaps from children that are spendthrift, children that have drug addictions, children that have special needs. So let's put a foundation here. In addition to the personal issues that might befall a family, such as I mentioned, spendthriftiness, drug addiction, special needs, things like that, we also have a tax foundation. So there are really 2 types of taxes when someone passes away, and that you have to be conscious of when you're planning. One is an estate tax. The other is the inheritance tax. They're dramatically different. So let's talk about inheritance tax first. The inheritance tax is a personal tax to the person receiving the inheritance. It's to the beneficiary. That means it's a bottom line number. So the estate has $1 million, and out of that $1 million, you've got probate costs and lawyers' fees and prior debts. You deduct all those. And then the inheritor, the beneficiary, the recipient, pays tax at specified rates on what they get. In Pennsylvania, spouses and charities, they pay nothing. Lineal relatives, children, grandchildren, parents, grandparents, 4.5%. Siblings pay 12%, everybody else pays 15%. So again, that's a bottom line number. Even if the estate is worth $1 million, the beneficiaries won't actually come into that a full $1 million because there's expenses. New Jersey has largely eliminated their estate and inheritance tax. There's some more nuance to it that we can get into later in the discussion if we have time, or you can certainly reach out to me afterward. but generally speaking, children, siblings, certain classes of beneficiaries, they don't pay anything on the New Jersey level. Now we have the federal estate tax. An estate tax is much different than an inheritance tax. An estate tax is a top line number. The estate is worth money. You pay tax on that money. And the most estate taxes are on the federal level. Very few states have estate tax. Even very few states still have inheritance tax. But we're talking about the federal estate tax here. And it varies from 18 to 40%, depending on the size of the estate. But for everyone on this call, everyone on this meeting, everyone on this seminar, if you are a single person, you may gift during life and at death combined $11.58 million without paying a penny of federal estate tax. Let me say that again, $11.58 million. If you're married, it's twice that, so close to over $23 million that you can gift without any estate tax. And what I just previously said was during life and at death. I want to pause for a moment there and explain another concept. I frequently hear, and Mark, I'm betting you do too, a lot of, I want to do $15,000 in gifts. I want to do $15,000 in gifts. I want to get it out. I want to get it out.
That's right.
That's often misunderstood. $15,000 is called the annual exclusion, which means you can gift, an individual can gift to as many other individuals as he chooses, $15,000 per person, without having to tell the IRS the gift was made. If you gift over that, you have to notify the IRS that a gift was made in excess of the exclusion, but you still won't owe any taxes, any gift or estate tax, until your lifetime gifts in excess of $15,000 per person and your estate at death total that 11.58 million or 23 million for a married couple. So I'm not saying rush out there and give away everything, but I am saying that you don't necessarily have to be concerned about making a gift of $50,000 to a child to help buy a house, or $100,000 to a grandchild to pay for college. You may, most likely under the current rules, won't have to pay any tax on that.
So Bryan, that's
so Mark, any questions on this so far?
Yeah, there's a one question, but I want to make a point about that because that is an often misunderstood concept. I get asked that all the time about the $15,000 threshold, that exclusion amount. And many people also think that the person receiving the gift will pay tax, which is
right.
Right. If I decided to give Bryan $100,000, that's not going to happen, Bryan. But
I was going to say, feel free.
$100,000, I would file a form. My account would file a form. It would come off of that $11.58 million exclusion when I pass away. The difference between the $15,000 and the $100,000, but Bryan would not pay any tax on that.
Correct.
So,
and actually, Mark, you articulate that very well. As I mentioned, the estate tax is a top line number because the estate stands in the shoes of the decedent. So that's an easy way to think about it. The recipient of the inheritance doesn't pay the estate tax. The estate or the person, because the estate stands in the shoes, is paying those taxes. That's very well articulated.
Thank you. And that's a really big number. And most people are probably thinking, geez, I'm never going to hit that. And, probably the majority of folks aren't, right? But if you have a business, if you have a farm, if you have, multiple properties, you could. So you've got to.
Or life insurance.
Or life insurance, right? Because that all goes into your gross estate. Life insurance is a great way to pass funds tax-free if they're titled correctly, especially. But they're all part of your gross estate, or can be. So that's really important too. But oh darn it, what was I going to say? I lost my train of thought. That's okay. It might come back. But my point is that we are, you folks on this call hear me talk about the changing condition of our taxes within the next 10 years. And it used to be that, in the next 10 or 15 years, I used to say the next 10 or 15 years, taxes are going to increase, if not double. And we talk about the marginal tax rates. Well, now that's really within a 10-year window, in my opinion. And this is certainly going to be on a chopping block, this big federal estate tax. So I can't guarantee it, but, I used to stand in front of the classes and say the the stretch IRA is going to be taken away one day, and here we are.
Oh, that was such a boondoggle, man. It was what a gift to people that inherited when that was the thing for about 30 years.
Yeah. Yeah, and there are some people that still can take advantage of it, but it's a really small pool of individuals.
Yeah.
And it's really a shame. So don't be surprised if this suddenly becomes a $5 million number.
Correct. And that a lot of planning goes out the window. You know, for the better part of almost 15 years, we've been planning with really high unified credits. So if this drops significantly, and I was a little bit more pessimistic than I am now. I think you're right. We're going to see some big changes, but the estate tax is such a football. I'm curious to see which way it's going to go. If it drops significantly, $2, $3, $4 million, that's a lot of dough. But there's a lot more people with $4 million than 22 million.
Sure, that's easy to get to.
Right, exactly. Particularly with life insurance and real property.
And real property. Yep, that's the big thing. You know, especially where we live in this area, you can have a pretty modest house at $1 million pretty quickly.
I agree.
And so you got to really pay attention and stay on top of these things. And you always hear me talk about talking to the folks out there. You always hear me talk about reviewing your plan every single year, and this is one of those reasons. You know, when I started in this business almost 20 years ago now, the lifetime exclusion was $650,000. Oh,
crazy.
Yeah, that is crazy. But and it's really kind of ping ponged around a lot since then. But it wasn't that long ago when it was $5 or $3 million, and there's a discussion in Washington about bringing it down to $1 million. And we did some aggressive gifting with quite a few families, and to make sure that we gift away as much as we could. And there's some good strategies around that. But yeah, that's why you got to stay on top of these things. And I'll put a plug in for Bryan, because Bryan might be the only attorney that I've ever worked with who reviews his clients' plans every single year, their estate plans. Now, I always tout the benefits. I was talking about the team, your certified financial planner, your qualified attorney, and a CPA. And I should believe it should be a CPA, in my opinion, and all working together. And Bryan is the only attorney, frankly, I know that will review your plan every year proactively. Yeah. And not to be negative, most attorneys are reactive, right? When you call them or email them, that's when they jump in, and most of them do it very, very well. But Bryan and his team, they do it differently, and I appreciate that.
Thank you. I appreciate that, and that's true. And it's critical, every year, or if there's a big change in circumstance, right. Divorce, birth, death, move, retirement, anything like that. That's exactly right. Mark, was there a question on the tax side?
Let's take a look. I have 2 questions so far.
Sure.
So let me, we have a question about your documents. I'm going to come back to that for a moment, or in a moment. There's a question about tax. So how does the gifting you don't need to report affect Medicaid look back?
Okay. Well, that's somebody who clearly knows I'm an elder law attorney and knows what elder law attorneys do. Again, another very common misconception that a lot CPAs have trouble with. I hear this with some frequency. Any gifting, regardless of amount, falls inside what's called the Medicaid 5-year look back. So what does that mean? If you need a nursing home or home care or New Jersey assisted living, and you can't pay for it anymore, you can apply for Medicaid, medical assistance. It will pay for you, pay all your costs for the most part. But a component of that, in addition to being broke and needing long-term care, you have to satisfy the 5-year look back. And that's where a caseworker examines 60 months of all of your financial records, tax returns, bank statements, retirement accounts, and their own asset verification system called the AVS, to see if you made any gifts or transfers of assets for less than fair value. Whether it's $1,000, $15,000, or $150,000, they add them up. They divide it by the average cost of nursing home care statewide, and the result is a number of months that Medicaid won't pay for you. Currently, every $11,100 in gifts is a 1-month penalty. So if you decide to give away your $500,000 shore house, you'd have about a 4-year penalty where Medicaid won't pay for you. And remember, you're broke, you need care, you have no way to pay for it, and you have that penalty. So any divestiture planning, which we're going to talk about next, it's one of the advanced strategies. has to take that into account depending on your net worth. If you are very wealthy, you don't have to be as concerned. If you are right in the bubble between $500,000 and $3 million in net worth, solidly 90% of Americans, you have to take that into account, that you might have the need for long-term care and need Medicaid to pay for it.
Yeah, I tell a story in my class when I have time about another attorney who referred somebody to me for a Medicaid compliant annuity. And she was sitting across the table from me and telling me about her parents who had an accounting firm in Northeast Philadelphia, had saved about $1 million, had a house up here in Bucks County and a house down in Naples, Florida. And long story short, they both ended up needing care. Dad passed away. Mom was then in a nursing home. And this woman was sitting across from me and said, so I heard that you can help us set aside this last $35,000 that mom and dad have. So that's
Yikes.
A few million, a couple $1 million at least between the savings and properties. 35,000. That's a common story, isn't it, Brian?
I mean, you know as well as I do, long-term care, you're going to pay $150,000 a year for it.
Sure.
And that the time horizon is getting longer because the number one need for long-term care is cognitive impairment.
Mm-hmm.
It's not strokes, it's not MS, it's not Parkinson's, although that's a big driver. The number one driver of long-term care is cognitive impairment, dementia.
Yep. And
the time horizon for that, depending on the type of dementia, is 8 to 20 years.
Mm-hmm.
So you're talking $100,000 a year for 20 years. That's the whole nut.
Yeah. Yeah. I was at an insurance continuing education class a couple of years now, 2 or 3 years now. And I was listening in one ear, typing an email in another. And
Mm-hmm.
the woman said that the average claim for dementia from the insurance industry was 8.2 years. I stopped typing and I almost fell off my chair, because
remember the average length of time in a nursing home for physical care is 2.6.
Mm-hmm.
It's 4 times as long for dementia.
Yeah. Yeah. It's really troubling. Those are the things that keep me up at night when you're talking about financial planning for clients.
Me too.
So Lewis asked, going back to documents, where would a HIPAA form reside?
So a HIPAA form or a HIPAA release, the HIPAA stands for Health Insurance Privacy and Accountability Act, Health Insurance Portability and Accountability Act. It established that all medical and healthcare information is essentially private with limited exceptions. Typically, I would want that to reside in your healthcare power of attorney. There should be a clause that references your agent being authorized to access HIPAA protected information and confidential healthcare. I always caution against removing it from that and making it separate because it's very easy to get lost. So you want to condense as much as you can to that document.
Good point. And let me just say that, and I don't think I said this in the beginning, when we terminate this webinar tonight, you're going to have an opportunity to schedule an appointment with me if you have any follow-up questions. So my calendar will populate and you folks know how this works. You can choose a time to spend some time with me.
And I'll of course give you my email address for follow-up questions as well.
That's exactly what I was going to say. So if you need to reach out to Brian and for whatever reason you didn't capture his information, just send me an email and I'll send you his information as well. Because everybody on this call has my email address.
Great.
Steve asked a really good question. If I can ask another before we move on. So regarding the Pennsylvania inheritance tax, is it applicable if the decedent was a PA resident, or is it if the inheritor is a PA resident, even if the decedent wasn't?
That was Steve?
Steve. Mm-hmm.
Great question. That's a very, very good question. So the inheritance tax applies to the residency of the decedent, regardless of the inheritor's state of residence.
Interesting.
And it only applies to in-state property. So what that means is any money is considered in-state, regardless of institution, because the decedent lived there, and real property. If you own a beach house, a shore house in Florida, a place in Arizona, it is exempt from Pennsylvania inheritance tax.
Okay. Good question, Steve.
Yeah, it really was. Okay. So let's talk about some advanced estate planning strategies. Now, the first one is a revocable living trust. We don't need to go into too much detail on this, but I will talk about what it is, why I recommend it. But the reason we might not spend a lot of time here is, number one, Mark and I spent, we did about a 90-minute discussion on this just in June about my evolving thoughts on revocable living trusts. But also, this really isn't that advanced anymore. I use revocable living trusts as a very common tool. But where we can pause here is to talk generally about what a trust is and how they operate to give you a frame of reference. So a trust is nothing more than a bucket that can own things. It can own houses, it can own cash, investments, stocks, bonds, securities, cars. It can own anything with the exception of actually all retirement accounts. A trust cannot own retirement accounts, they only be in an individual's name. And the benefit of a trust is multifold. We'll talk about what that means. But all trusts operate in the exact same manner in their purest function. They designate a creator, which is the grantor. They designate a trustee, who is the individual charged with overseeing management of the trust. And they designate a beneficiary, the person that derives a benefit from the trust. And those three roles can be played by the same person, 2 different people, 3 different people. You can have multiple creators, multiple trustees, multiple beneficiaries. And the purposes of the trusts that you choose differ wildly. So starting with an RLT, revocable living trust, typically, not always, but typically, an RLT is created for the grantor, the creator, to maintain control over their assets while also avoiding probate and easing the management of their estate. So in a revocable living trust, the creator typically will serve as the trustee and the beneficiary while the creator is alive. So they maintain total control over it. They can write checks out of the checking account. They can borrow against the equity in the home. They can talk to the investment advisor because the trust is essentially their alter ego. And I mentioned that it avoids probate. Probate is the process in which you take a will to the register of wills to prove it's an actual will, and then create an estate. And an estate is an entity. It's like a corporation. With the estate, you collect all the money. You got to advertise that someone died. You've got to pay debts. You got to do all these formalities. And then you pass the money to the beneficiaries. The downside to probate is what I just mentioned. It takes time. There's formalities. It's time consuming. It costs money, and it's delayed. The pandemic has delayed even longer, but it's not unusual to wait 2, 3, 4 weeks just to create the estate. And that means you can't access money if those funds are frozen when somebody dies. So the trust can avoid the need for probate. And I often recommend it for people that have real property, a house, because you can avoid probate with the right planning. Every other asset you own, or almost every other asset you own, can avoid probate with POD, TOD, ITF, joint ownership, as Mark has already talked about, except a house. If a house is in a single person's name, there's really no way to avoid probate. It's got to go through it. So by moving into a trust, you can streamline that. But even more importantly, in my opinion, I've had so much difficulty with using powers of attorney. Banks are pains in the butt. They don't want to accept powers of attorney. They scrutinize them. They scrutinize what the language is, what kind of authority you have. Point in fact, I'm working with a young man, not a young man, he's actually in his 60s, young-ish, we'll say. His parents are in a nursing home in Northeast Philadelphia, and they had no powers of attorney when he came to me, and he had to get access to their funds. So we scrambled to get powers of attorney put in place. It was a huge hurdle at the bank. It was a big problem. The bank had to scrutinize it. It took 3 weeks to get it approved. And then, as part of our planning, I recommended, to avoid probate, he goes and puts himself on there as the beneficiary. He's the only child. The bank said they don't allow agents to also be beneficiaries on the accounts, which is lunacy, but we couldn't fight it. We wouldn't win. Had everything been in an RLT, or had we shifted things into an RLT when we knew there was going to be a problem, we would have ease of management. So had his parents come to me, a few months earlier, and I knew we were going to have problems with powers of attorney, we could have created the RLT, moved money into it to make managing their affairs easier. Downside to the RLT, 0 asset protection. It doesn't protect you from creditors. It doesn't protect you from lawsuits. It doesn't protect assets from long-term care expenses like Medicaid. So it doesn't protect you from any of that. It's mostly an estate management tool. So before we move on to the irrevocable trust, any questions?
The question just popped up. Let's see here. Roseanne asks, do the properties in a RLT count in the total figure for federal estate tax purposes? Great question.
Yes, they do. An RLT has, the best way to look at it, it's as if it never happened from a tax perspective. All sitting in there. Great question, though.
Yeah.
Okay. So, an irrevocable living trust. Well, this should come as no surprise. The money, when you put it in, you can't get it back. So, thinking about that triangle of the players, the creator, the trustee, and the beneficiary. An irrevocable trust is generally used for asset protection or to create dynasties. So the creator will appoint a trustee, and the trustee will manage the funds for the beneficiary. Typically, the creator appoints an independent trustee, someone different than the creator. And the beneficiaries can be the trustees, can be charities, can be grandchildren, can be whoever you'd like. The reason you choose irrevocable, though, most of the time, is for the asset protection you get from it. Because once the creator, once the grantor transfers money into that trust, they cannot get it back. They might reserve an income interest, possibly, although not always, meaning the income from the trust can pay to the grantor. They might retain an interest to live in the house. If they put the house into the trust, they may not. It depends on the needs. But you get asset protection. Because the trust is irrevocable, it doesn't belong to the grantor anymore. It doesn't belong to the creator. It belongs to the trust, and the trust has its own tax ID number. Unlike an RLT, an irrevocable trust gets its own Social Security number called an EIN. And there's all these rules that govern it. The trustees oversee it on behalf of the beneficiaries, and the trust dictates when the trustee can give money to the beneficiaries, how much they can give to the beneficiaries, and for what reason. And we could spend hours going into what the reasons might be and how much and how little. That's part of the planning process. Whether you need an RLT or an irrevocable trust is based on our conversation. What are your goals? What are you worried about? What do your assets look like? Once we settle on a type of trust, if it's appropriate, then we talk about the details. Who are the beneficiaries? Who are the trustees? What are the rules of distribution? What happens when somebody dies? All of that. Now, similarly to an RLT, the irrevocable trust avoids probate, and the assets can be managed even more easily because you're often appointing a trustee that isn't the creator. So there's no hoops to jump through if the creator is incapacitated because the trustee is already working there. The downside to the irrevocable trust is the loss of control. The trustee has no more control over the assets. Now, it's not always the truth. Not always the truth, but when there is a loss of control, it might be total or partial. That's the downside. So it's about having the conversation to figure out what is appropriate for your needs based on your worries. That's the conversation with your planner. Now, we also have in the irrevocable living trust category is an ILIT, or an irrevocable life insurance trust. This is a way for large estates, valuable estates, to move life insurance, make it non-taxable on the federal level, so the beneficiaries can use the proceeds from the life insurance policy to pay the estate tax if there is one. ILITs are most commonly used when you have illiquid estates, meaning you have a business, a family business is very valuable, and you can't sell it, and it's worth millions and millions and millions of dollars, and the taxes could be really high. You use an ILIT. If you own a family farm, lots of real estate, those are times you would want to look into an irrevocable life insurance trust. Now, before we move on to additional creative strategies, any questions on the irrevocable living trust side?
I don't see any questions, Brian. I just want to comment when it comes to trust planning. This is again back to that team. people often want to set up an irrevocable living trust to avoid the estate taxes that Brian was talking about. And oftentimes they count on the fact that they can still receive income from the trust to take care of their needs, even though they're really gifting that money away. All the things Brian,
Correct.
you don't have any control. It's no longer yours, really. What you have to be careful about is the trust tax rates are pretty outrageous. So while you may get a benefit from an estate tax point of view, you're going to pay really high income tax on that income. So you have to be very careful how that's done.
And Mark, that's a great point. The highest tax rate on trusts, I think, is at $14,000. So 14,000 in income, you're paying essentially 37%.
37%. Yeah. Mm-hmm.
Now, fortunately, we have strategies that can transfer funds to an irrevocable trust, but avoid trust taxation. They're called complex irrevocable trusts.
Mm-hmm.
And the taxes are attributed to the creator, the grantor, and goes on their tax return. So the trust can generate lots and lots of income, and the grantor can pay it at their rates. Now, granted, the downside is the grantor's got to pay the taxes on assets they don't have any access to, but at least you know you're going to be charged at much more favorable tax rates. It's a great point.
Yeah.
Okay.
Roseanne's got another question before we move on. What would you say your assets would need to be to make an irrevocable trust a possibility, or to make it make sense? I guess, Roseanne, is what you're asking.
Roseanne, there's no answer to that. It's a good question, but I have a family that put 50,000 into an irrevocable trust, and they were not wealthy people. They said to me, the husband has Parkinson's, he's still alive, and their net worth, exclusive of their house, was about $250,000. They knew that husband was going to require a nursing home, and they said, we want to preserve just a little bit as a legacy for our children. How do we do it safely? And their kids had some problems, so we couldn't just do an outright gift to them. So they put 50,000 in. I have families that put far more into it, $500,000, $1 million. It all depends on what their needs are. So I would say to you, it's a personal value. What is important to you? To this family, 50,000 just to their kids, that was a tremendous amount for them. He worked really hard for it, and it was worth it to him to do it. I have other families who would say 50,000. That's nonsense. That's not enough. What's the point? So explore what your values are. If you want to protect resources, regardless of the amount, an irrevocable trust might be right for you.
So I think what I hear you're saying in an answer to that is, you were talking about Medicaid planning. It sounds like with that $250,000, right? You're moving that to an irrevocable trust. So
yeah, that's right.
So that really, once you move it into the trust, that starts that 5-year clock running, right?
Correct. Exactly right. So that way, if you make it through 5 years, and we have now, that family came to us in 2015. That 50,000 is totally exempt from the look back now. So it is all but guaranteed that it will go to their children when husband and wife die.
And you can be very specific about how it's distributed to the children.
Yeah. As a matter of fact, this stays in that trust, and the trustee can use it for appropriate things. There's a drug addiction issue here, is what it comes down to. And the parents don't want to give it to them outright. So they put some additional protections in there. That's right.
Sure. And if we did the same with a revocable living trust, with the idea that would help with Medicaid planning, that's just not going to fly, right?
Correct. Everybody thinks an RLT has the same protection, but it doesn't. An RLT, because you as the creator have the right to revoke it, it's your money. And actually, point in fact, Mark, when it comes to Medicaid planning, let's use husband and wife with the 50,000. If husband goes into a nursing home, their house is a protected asset, meaning the wife can stay there. It's hers. We had to do some planning with it, but it's a protected asset regardless of her husband's need for care. If that had been in an RLT, it wouldn't be protected. We would have had to have pulled it out. So you have to look at all of those when those issues come up, when it comes to Medicaid planning, long-term planning. You might need to flip the RLT. You might need to move the assets out of the RLT in order to access public benefits. And then once you access them, you can certainly move it back in if you'd like.
So that's a really good point, because that protected assets or countable assets is such an important term in your world with Medicaid planning.
Yeah.
And how many times do you see it where the family says, "Oh, now we sold the house," or liquidated the IRA or something like that, or mostly sold the house, which is now you've created something that eliminates something that was protected, and you've created accountable asset, right? Because you've sold the house for $300,000, put it in the bank account with the idea that you've got funds now to pay for mom's care.
That's right.
Yeah. So it's
And then you shot yourself in the foot.
Yeah, it's so important to have a conversation with someone like Bryan, and I'd say specifically Bryan, before you get into these issues, because unfortunately, so many times I think Bryan probably feels like he's chasing the bus after it left the bus stop. You know?
Oh, you have no. I would say over the last 10 years ago, if you asked me, I'd say 95% of our elder law clients were crisis planning.
Mhm.
But this is crisis, meaning mom needs a nursing home and she needs asset protection for dad tomorrow.
Mhm.
We have seen a gradual shift. It's much more common now. It's much more top of mind how expensive care costs are. So I'd say about 65% of our families are crisis. We're seeing a lot more people coming in saying, what can I do today to protect myself? You know, Mark, as you know, we take a unique approach to elder law in that our firm is comprised of attorneys, but also social workers that we call care coordinators, who help to put care plans in place for people and families that have a care need, but not necessarily a Medicaid need. You know, they might need assisted living or home care. They might need an occupational therapist to make the home senior friendly. So people are coming to us earlier and earlier saying, I'm a healthy older person, protect me financially and legally, great. I'm an unhealthy older person, but I'm not that unhealthy. I'm not looking at care need tomorrow. What can I do to stay home? What can I do to make my home senior friendly so I can age in place while also protecting myself legally and financially?
Yeah, important.
You've got more flexibility. The earlier you plan, the less expensive it is. The more flexibility you have, the more options you have because you got time on your side.
Mhm. Yeah, great points. All right, we have two questions. I'm going to answer
Sure.
these two here, and I'm going to let Bryan move on. So Walter asks, is an irrevocable trust excluded from PA inheritance tax?
Depends on how you draft it. It can be and it can't be. Or it may be and it may not be is a better way to say that. If you want it to be excluded from inheritance tax, you're going to give up a lot of favorable income and capital gains tax treatment. If you want it to be exposed to inheritance tax, you can retain favorable income and capital gains tax treatment. Most of the time, I don't worry about Pennsylvania inheritance tax because frequently the beneficiaries are a spouse or lineal descendants, and 4.5% is peanuts.
Mhm.
It really is. If you have substantially appreciated assets, you would rather pay inheritance tax than capital gains tax. And when you inherit assets, the tax basis, meaning how the government calculates capital gains tax, the tax basis steps up to the date of death value. So let me use a real world example there. I got a client, I just spoke to him this morning. He paid $16,000 for his house. It's now worth $350,000. If he gifts that to his son today, and his son then goes to sell it, his kid's going to pay capital gains tax on $336,000 worth of capital gain. If dad leaves it to his son at death and the son inherits it, the value steps up to the date of death value. If he sells the next day, doesn't pay any capital gains tax. And 4.5% of 350,000 is a whole lot less than 15 to 20% of 285,000 or whatever the difference is.
Mhm.
So you have to look at which is more valuable, which is going to be more cost savings. If there's no capital gain, maybe an outright gift or a simple trust makes sense to avoid the inheritance tax, but it all depends. Because another little sticky issue, any gifts made within a year of death are clawed back into the estate and taxed.
Yeah.
So deathbed gifting is still going to be subject to inheritance tax.
Yeah, and you know, talk about the chopping block. Capital gains is on the chopping block for discussion for changes to the tax code. So I'm willing to bet that if we have this discussion 2 years from now, that we might be saying, remember when capital gains were stepped up at death? Right.
I agree with you. I think it's a more of a boondoggle than the stretch IRA. I mean, you're talking, the government is forfeiting millions of dollars in capital gains tax and it arguably makes no sense. There's no logic behind it. You know, you're talking With the estate tax, I see both sides of the argument. One side of the argument is it shouldn't exist. People have already been taxed on that money.
Mhm.
They paid their income taxes, they paid their capital gains taxes. Why are you hitting them again? The flip side of the same argument is the United States was built on non-dynastic wealth. When we threw off the shackles of feudal England, it was to not be subject to very few landowners and wealthy individuals who lease out their land on 99-year leases. And England is known for a lot of concentrated wealth. So the idea behind the death tax or the estate tax was to limit that concentration of wealth over generation after generation. But the step up, it's taxes that would have had to be paid because that's what the law is, and all of a sudden just disappears.
Yeah.
So it seems very illogical to me, but don't get me wrong, I avail myself of it on a daily basis.
Yes. Yeah, and it's a real benefit for folks that are paying tax on a lot of other things too. So when you inherit an IRA, there's a tremendous amount of tax. So
Oh, you get clobbered.
yeah, it can be very helpful. So yeah, it's going to be a shame, but listen, the math tells us, everybody knows what I think. The math tells us that taxes have to increase dramatically.
Yep.
There's no way around it. It's not a Republican thing. It's not a Democrat thing. It's a math
Nope.
issue. So these are estate tax and capital gains tax are really low hanging fruit.
They are. And you look
there
at
are
it,
a few people out there, advocating for keeping the stepped up basis for capital gains.
And I don't take a position on it, but Mark, to your point, I take a position on the fact that in the 1920s, 30s, the highest marginal tax bracket was, I think, 78%.
Mm-hmm.
And now the highest marginal tax bracket is half that. It's like running a business. You can't cut your way to profitability. You got to either charge more or raise your costs. And that's what the government is. They're going to have to raise their costs by raising taxes.
Yep. 94% was the highest marginal tax rate we've had in this country. And that was at the end of World War II.
All right, there you go. There you go. I stand corrected. 94% in 1945. That was on the equivalent of what? About $1 million today?
It's about $3.2 million today.
3.2 million.
Yep.
So, if you're making $3.2 million a year, I'm okay paying. If I was making 3.2 million a year, I'd be okay with the 94% on my last million. Still making a ton of money. Not a lot of people agree with me when I talk about taxes.
I'm going to remember that.
I look at it,
you're in the minority there, but that's okay.
I am.
I think that's very gracious.
My father raised me on our taxes are a moral covenant with our government, and their moral covenant with us is roads and Social Security and Medicare and national defense and education. Now, I think there's arguments on both sides that I think we've all failed or we've all succeeded, but I look at my taxes are my moral covenant to support those around me and support my government. So it hurts, but I'll pay it.
I agree. Okay.
So
one more question before we move on.
Yeah, absolutely. Go for it.
So Roseanne's asking about the protected asset. So if the house is a protected asset in your description, if the husband goes into a nursing home, does the wife keep the house when he dies, or is it only protected for as long as the husband is alive in your example?
Wife would keep the house. So if husband and wife own the home, husband goes to a nursing home with the right planning, when husband dies, the house remains protected. When wife dies, it would either get passed to her heirs as she chooses, or if she was in a nursing home or needed to sell it to pay for care, she would sell it to pay for care. But if the husband dies first, house is absolutely protected. If the husband dies second, at the very least 2/3 can be protected, if not all of it.
Okay, good answer.
Good question. Okay. So next we have divestiture planning. That's a lawyer fancy word for gifting. You can gift money. That's an advanced estate planning strategy. I had a conversation with a wealthy individual today, worth about 14 million bucks. And he said, should I be giving money to my kids? And I was like, we talked it through, and ultimately the answer was no, because he just doesn't want to do it. But yeah, you can give away money. Why not? Give it a shot. If you want to just start reducing the size of your estate, you can gift it to kids, you can gift it to grandkids, you can gift it to 529s that are owned by your kids or your grandkids. I'm sorry, that benefit your kids or your grandkids. There are ways to just reduce your estate by divesting yourself. I strongly more so than anything else here, encourage you to seek counsel if you're considering significant gifting plans. And when I say significant gifting, I mean like the majority of your estate, because there are all kinds of downsides: capital gains tax issues, income tax concerns, the 5-year look back, and the worthiness of your children. You know, I trust the children of my clients, but I don't trust kids as a class of people. You know, I've seen too many children just take off, steal the money, misspend the money, use it improperly, refuse to give it back if they need to. You know, it really needs to be part of a comprehensive approach to planning. And I rarely recommend outright gifting except in very specific circumstances.
Mhm.
So moving forward to some really creative strategies. There are charitable planning options, 3 of which I've included here, and these are the most often utilized. One is called a charitable remainder trust. You can do a charitable remainder uni trust called a CRUT, C-R-U-T, a charitable remainder annuity trust called a CRAT, and I'll explain what that means. A charitable remainder trust, the long and short of it is, you are investing money either in a trust or into an annuity that says the trust or the annuity is going to pay you on a regular basis, monthly, quarterly, yearly, for the rest of your life. At the end of the day, when you pass away, everything else that's left there goes to charity. And the benefits can be pretty nice. I'm working with a woman now. I'm her agent under power of attorney. You know, we have unsupported elders. I often step in to serve as their kind of rent-a-grandson. We do all the daily money management. We work with their financial advisors, and we serve as their agent. And she has a charitable remainder annuity through In Faith. It's a religiously affiliated institution, and it pays her $16,000 a month, a quarter. So she's making about 52. I can't do math in my head. That's 40 plus 24, $64,000 a year they're paying her. Now, I didn't sell this to her, of course. I'm not a financial advisor. Her advisor did. But the benefit is she's going to get this for the rest of her life. And she's in assisted living, and she's paying about $10,000 a month. So that $16,000 every quarter comes in really handy to paying towards care costs, and we know it's locked in. And at the end of the day, she knows that she's leaving a nice charitable bequest, and she doesn't run the risk of running out, because it's very important for her to leave a charitable remainder. That's a charitable remainder annuity. The alternative is a charitable remainder trust. And that's a trust that is created by the decedent, either through his will or at life, and it's funded with money. And the trust says, I want you to give to my 2 children 5% or $5,000, the greater of the 2, every year for the rest of their lives. But when they die, everything goes to charity. The benefit here is you can still leave money to your children, but you know that there's going to be something left over at the end of the day. Because if you're giving 5% a year, it will never deplete. It can't, because if you have 100,000, you give 5%, you got 95,000. At the next year, you're not giving 5,000, you're giving 5% of 95,000. So inevitably there's going to be something left over, even if it's just cash. So that's an option to maintain, give a little bit to your kids, and also maintain a charitable bequest. Another alternative is a donor advised fund. You put money into a fund, it's a charity, and during your lifetime, you can direct it. You can say, this is what I want you to spend money on. It's a special account. I want you to invest here. I want you to invest there. When you pass away, it goes to that charity. And the final one for our discussion today, there's tons and tons and tons of options here, is a charitable lead trust as opposed to a remainder trust. This works in the opposite of a remainder trust. A charitable lead trust is you put money in a trust, and every month or every year, every quarter, the charity gets a distribution, like that 5%. Then at the end of the day, the remainder goes to your children or other chosen beneficiaries. It's like a reverse charitable remainder trust. So those are nice ways that if you are charitable in the sense that you absolutely want to leave something to charity, there are ways to do it without completely cutting out your children or running the risk that you're going to deplete all of your assets and not leave anything to them. Mark, any questions on these?
I don't see any questions, but do you want to talk about the tax benefits of charitable remainder trust, charitable annuity trust, and
Yeah, I mean, the benefit here is there's no inheritance taxes. There's the charitable lead trust, huge income tax deductions because it's charities. Charitable remainder trust reduces estate and inheritance taxes. And also, Mark, to your point, on the tax planning side and the charitable planning, if you want to leave money to charity, make it out of your retirement account first.
Mhm.
At least that's a good recommendation,
Mhm.
as opposed to cash. Let me explain what I mean. Imagine a situation where you have a dad. He's a widower. He's got 500,000 in his retirement account. Got 500,000 in cash. He says, "I want to leave $500,000 to charity." He is better off, and his children are better off inheriting cash and having the retirement account go to charity, because charity's not going to pay any taxes, like pay any inheritance tax, anything like that. And the kids are going to inherit a full 500,000. They're not going to have to pay income taxes on the IRA withdrawals that they would be taking.
Right. Good description.
Any other questions there?
Howard has I think it's more of a comment.
Sure.
Let me just read through it for a second.
And I also would like to point, going back to the taxes, the charitable gifts.
Mm-hmm.
I have heard some advisors suggest their clients take money out of their 401ks, IRAs for their year-end charitable contributions. Mark, I don't know what your thoughts are on that. I tend to tell clients to shy away from that and not pull out of their retirement accounts to do year-end charitable giving.
Well, unless they're doing a qualified charitable distribution.
That's fair. My concern is they're giving up potential future growth on those dollars.
Yeah, and even I'm a strong advocate for Roth conversions, and often I'm telling people to deplete sometimes all or a majority of their assets, their IRA assets via Roth conversion. But when someone tells me that they're charitably inclined, I pull the brakes back a little bit, because as you said, there's no reason for you to pay tax on those monies, whether it's via distribution and then transfer to a charity or Roth conversion. If you're going to leave X number of dollars, even if you have money at the end of your life and you know that there's a portion of that going to charity, it doesn't make sense for you to pay tax on that money, because the charity is not going to pay tax.
Correct.
So it just doesn't make sense. And I do work with a lot of folks that don't have kids, and there's they will be leaving money to charities, and there is there's a lot of benefit to these charitable trusts for that too, and to offset income tax and the charitable trusts. So these are really great estate planning techniques, and it can help with things like Roth conversions.
And it's a great way to get your portrait on the wall at the charity. Penn State has a wall of contributors, and the size of the portrait indicates the size of the contributions. At least that's my own anecdote.
So Howard just has a comment. I'm just going to summarize his comment, and he seems to think that the stepped up tax and estate tax rates and exclusions are more likely ways to raise tax revenues than changing income tax brackets, and it seems more fair. And he says, since lawmakers are generally wealthy, boy, isn't that the truth? Perhaps not as likely as should be the case. Yes, I think that is the low-hanging fruit if we're just speculating, but it's going to hit the marginal tax rates also, because it just has to.
It will.
Yeah.
And I think that also when you're talking, in my opinion, I think the estate taxes, if they should be tied to, I would like to see it tied to the net worth of the inheritor of the beneficiary, as opposed to the size of the estate. I don't see how it's fair for a beneficiary that's worth $10 million to pay the same 40% to a beneficiary that's worth $500,000. I'd like to see a tiered approach to it. And now that does exist now. It's a sliding scale. It's a sliding upward scale based on the size of the estate, but it's not based on what the beneficiary is getting. And I just tend to think that might be a fairer way to do it than to just slide the scale up, make it progressive rather than regressive.
Yeah, interesting.
But that's what I do on Saturday nights. I pour a bourbon, I sit and I wax on tax issues as my wife claws her eyes out with a fork. So moving forward, There's been a lot of talk about family limited partnerships. And a family limited partnership in its simplest breakdown, it's a business or a holding company that's owned by multiple family members, usually two or more, in which each family member buys shares in the venture, whatever's in there for potential profit. Inside this limited partnership are a general partner and limited partners. Why do it? They're often set up, to preserve generational wealth within a family. It can allow for tax-free transfers of assets, real estate, and other wealth if done properly. They are, in my opinion, a little overutilized. They're not that complicated to set up. You can do it relatively easily. They are more complicated to manage on the tax side, on the beneficiary side. So if you have a closely held business, if you have a family farm, if you have a lot of shared investments, you might want to look at a family limited partnership, valuable real estate. A traditional estate, I'm not going to say no to it, but I think you need to have some more complex holdings that are illiquid too. I look to FLPs when you're dealing with illiquid estates. You might have real estate investment trusts that you're invested in that aren't redeemable. You might have private investments. Gentleman I was speaking with today, he has a lot of real estate LLCs, limited partnerships. He invests in a lot of private companies, startups, and things like that aren't public. There's no market. You can't just go and sell these things. So a family limited partnership might be beneficial there to take advantage of some tax efficiencies.
Brian, on that
Now,
topic, so
yeah, of course.
if I can, in that example, what do you recommend to people as far as valuations? So when you have someone that's investing in private companies, they may have a company of their own, maybe some real
Mhm.
estate. How often do you recommend that there's a valuation done on those?
If ever there's a transfer of wealth. So if you're allowing a child, a partner to buy in, valuation. If you're planning your estate and you're concerned about the valuation that it might boost you over the unified credit, you'll want to do a valuation there. If you're exploring some sort of advanced strategy, the downside to valuations, they're kind of hit or miss. You run the risk that you own a service business. What's a service business like? What my law firm? What's it really worth? We can get it valued, and we have, but the reality is, it's my partner and me. If we're not here, no one's going to buy shares in this firm because if he and I aren't here, it's not worth anything. So while I recommend it if you're doing limited partnerships, if you're doing charitable planning, estate planning, letting people buy in shares, don't put a whole lot of stock in it if it's not for one of those reasons.
So I always heard from an estate value point of view
Mhm.
that it's better to have a valuation done rather than let the IRS value your holdings.
Oh, absolutely. You're talking at
Well, I'm
death.
talking in general, but I'm adding this to the conversation.
You absolutely want to do a professional valuation. There's no question. We had a gentleman in a state we're working on. He owned a North Carolina, South Carolina, and a Pennsylvania-based business, three separate businesses. And there was all kinds of tax delinquency. There's so much going on here. One was an LLC, one was an S Corp, one was a C Corp. And we brought in a national accounting firm who went in and they looked at all these things. The family, when they came to us, they said, we're estimating each business is probably worth net about 10 to 12 million. And I was like, oh God, that means we have to do a federal tax return. And I was like, my stomach sunk. And I hate doing them. And I said, okay, well, we got to get it valued. They came in at like $6 million total. We saved them a ton of money. The valuation probably cost $20,000. We saved them, God knows, countless hundreds of thousands of dollars in estate taxes by doing that.
Yeah. And so do you find that most times the IRS will accept a recent professional valuation rather than counting on their own when they do that?
I would say that in my experience, I've never had a problem. But that is, I think, as they say in the financial world, past results are no indication of future performance.
That's right. That's right.
Yeah.
Yeah. Yeah, because it is crazy. So my own experience last year when I bought the property that I'm in now in Newtown, I did a business valuation because I borrowed some money for the property, and I was amazed at what the value came back at, and it was about twice what I would pay for my own business. Knowing what if I was.
It's crazy what they've, yeah, particularly when you have something that's non-marketable.
Mhm.
I don't know how you can, I don't know. I know what goes into it. I've seen these valuations, but it's like, it almost seems usurious to say this business is worth $1, $20, $1 million, when in reality, it kind of isn't.
Yeah, so many factors involved. Howard has two comments before we move on. He says a
Yeah.
CRUT, a charitable remainder trust, since irrevocable, is also excluded from assets for Medicaid qualifications after 5 years, yet can still keep the income stream. And then he puts a question mark on that actually. So that's not a statement.
So that's actually a very good point. There is some case law that's coming out that is challenging these issues. So let me take a step back. There are some very conservative states when it comes to Medicaid planning, and they're very aggressive in how they access assets. One of them is Connecticut, and I keep my eye on the case law that comes out of there. I read a monthly reporter. And as Connecticut goes, I tend to direct my planning because I know New Jersey is probably just months to years behind that, and Pennsylvania years behind it. But I want to be ahead of the game. So about 12 years ago, I think it was, we were doing irrevocable trusts for Medicaid planning, asset protection, that reserved an income interest and or a real property interest, meaning a right to live in the property, the house. And the income interest was any income generated went to the grantor, the creator, and that was theirs. And it worked. It was great. We were doing it for years. And then a couple of cases came out of Connecticut saying that if there was an income right, it's an includable asset, and they were going to court over it. I said, okay, well, that's something to think about. And then they started coming out saying a right to stay in the residential right, they're going to include it. So okay, so they kind of started to worry me. Then I saw North Jersey take the same approach, and North New Jersey tends to be a little more aggressive, as is Western Pennsylvania. And when I saw that, I changed all my practice. So a CRUT, it is irrevocable, and you have these charitable beneficiaries. I would be curious how a Medicaid office would look at it. So I would be reluctant to use it as an asset protection tool. We'd have to see how things play out. That's a very good question.
And Howard also asks about asset protection from lawsuits and divorce settlements.
With the right spendthrift provisions in there, you can protect from creditors, you can protect from divorces. The downside too, I don't do a lot of family law, so we'd want a family lawyer to espouse on this a little bit more. But when it comes to divorces, if the trust is funded without the consent of the spouse, it might be countable, meaning it might be exposed. But if the spouse consents to the transfer to this trust irrevocably, they might not have the ability to fight it. But creditor protection, yes, as long as you're not transferring it in to avoid creditors. Meaning, if you know you are indebted and you move money into an irrevocable trust, and you're on notice of that debt, they'll come after it. They'll invade the trust for that. But if you do it today and you move money to an irrevocable trust, and in 5 years you hit someone in your car and they sue you, the trust should provide pretty good protection.
Yeah, interesting. Good questions, Howard. All right.
Okay. And Howard, I think you've been on other discussions. I think you were on the one this summer too. So and you asked some really poignant questions then too. So I appreciate that. So the second to last, the penultimate, is the Qualified Personal Residence Trust, a QPERT. The goal of a QPERT is to remove your primary residence or any home from the estate for tax purposes. It can provide some tax advantages. It allows you to stay in the house. It can avoid estate inheritance, not inheritance tax. It can avoid estate tax. It can avoid some capital gains tax. The question you have to ask yourself is, does a QPERT make sense? And again, going back to the unified credit, at 11 point some odd million dollars right now, unless you have a lot of real estate, it doesn't. But as this starts to come down, you might want, as the unified credit starts to come down, you might want to look into these. Mark astutely pointed out when we first started speaking here, it's not that hard to get to $1 million or $2 million anymore in the United States. Between life insurance, retirement accounts, and real property, a lot of people are there. So if you can divest yourself in an appropriate way and get the house off the table, get the life insurance off the table, you might put yourself in a better financial, well, you might put your heirs in a better financial position. And then that brings us to qualified domestic trusts. I admittedly have never done one of these. They're called QDTs. The qualified domestic trusts, similar to an irrevocable trust, may be able to reduce or limit your estate taxes. It often is an irrevocable transfer. It's something you want to explore as part of a comprehensive approach to your planning. The reason I've never done one of these is because I generally have seen them reserved for really wealthy individuals or those individuals that are wealthy in real property. Now, we just spent our discussion today going through a lot of concepts. And I'll tell you, the majority on this call, I structured this in such a way from most likely needed to least likely needed, intentionally. Everybody out there we know needs wills and powers of attorney. We're not going to belabor that point. Many of you out there would benefit from a revocable living trust for a number of reasons. Many of you would benefit from an irrevocable trust, potentially for many reasons. Divestiture planning, charitable giving, that's pretty frequent. The FLP, a little less frequent, and the QPERT and the QDIT, they're far, far less frequent. And when I put these presentations together and I sit with people like Mark and we talk with individuals like yourselves, I've been in your shoes. And my guess is some of you are out there and you've got a little bit of sweat at the top of your brow thinking, oh man, should I be?
Okay. So folks, it seems like we had some technical issues, sorry, but I'm hearing that you can hear me only. Is Bryan back?
I think, Mark, can you hear me?
Yeah, I can.
Okay, I am back. How much of that did you get before I parted company?
I'm not sure if I cut off I disconnected. I told Bryan at the beginning that I was having some connection issues here. That if I dropped off, then he would take over, but it looks like both of us got knocked out. So, we talked in the beginning about how great it is to have these Zoom meetings. Now, this is the first time this has happened. So what I heard from you, Bryan, was that you went from most likely to least likely, and you were kind of wrapping it up.
And what I was wrapping up with, don't wring your hands and worry about it. Don't be overcome by worry on this. Ultimately, you're dead. And I know that sounds flippant and I don't want it to be, but it is in a way. You can do things to protect yourself today. You can do things to protect the legacy for your kids today, and you should. But if you're worried about, oh, what if my kids pay an extra 2% or 10%, it's all windfall. There is no 100% tax, which means no matter what, your kids will always inherit something. They might pay a little bit more, pay a little bit less, but it's always a windfall. So don't let it overcome you. Don't be paralyzed. Just come in and have a conversation. We'll work out the perfect solution for you.
Yeah, and it is most important to have that conversation. So, Bryan, this just, and I don't know the answer to this. Do you charge for consultations?
We have a $250 consultation fee. We do, but we apply it towards our fee for services, and that's only for the in-person consult. We have a qualifying telephone call before you come in to meet with me. You'll speak with one of our team members who will do a detailed dive with you to make sure we can help. Mm-hmm. So if you're going to sit down with me, it's certainly something that we're going to be able to help you with. The question is if you like me enough to hire me. Yeah.
Well, that's good. Yeah, and that makes sense. That makes sense. You don't want to waste anybody's time, right? Okay, let me see if we have any other questions. We're right on time. Howard said, I love that closing comment. Don't worry, you'll be dead.
Well, at least
and listen, just like you and I talked to a lot of people and over the years, I just can't even tell you how many people you sat down in front of with the yellow legal pad. And I always ask, what is your feeling about estates? And some people say, I want to leave a certain amount of money to my children. I remember one of my first clients said to me, I want to leave. He had 3 daughters, and he said, I want to leave $400,000 to each of my daughters because that's what my mother left me. And that was really great. And I often tell the story in my class that when he passed away, each one of his daughters got $1.3 million. So we, you know, 3 times that plus. And the majority of the assets passed within 30 days. So I pat myself on the back a little bit from a planning point of view. But most people say, I want to make sure we're taken care of, and whatever's left passes as efficiently as possible.
Yep.
It's always, and my notes always often say whatever's left, and everybody in my office understands what that means. And that's really the majority of the people. So when you're talking to Bryan, you're working with a financial planner, it's really just figuring out, identifying those issues. My job is to not have all the answers. I don't need to do Bryan's job. You know, there's people I count on. I'm not a lawyer. I'm a financial planner, and there's people I count on like Bryan. I've got a person I go to who is excellent with Medicare planning and health insurance planning. And that helps me because I leave that part of my brain open for other things, right? I can just send people to him or refer to him myself. And the same with Bryan, it's identifying those particular issues. Often things will just pop up for me and we'll say, okay, this could be an issue. Let's address it. And that's how the team should work. You know,
you're absolutely right. Mark, for everyone out there, Mark and I met with a handful of clients together over the last 2 weeks, and I made an introduction to some of the families I'm working with, and there were one couple they needed an investment advisor. Just that's a global. There was another problem. A client was having a very serious problem with his current bank, and I said, let's talk to Mark. He'll resolve this for us. I know enough to know there's a problem. Mark knows how to solve it.
Yeah. Great point. And that's really how your team should work together. So that's important. So, you know, have a conversation, spell out what you want to get done, what your thoughts are, and that will probably change, and that happens, and that's okay. And that's why you should review these things every year. Can't tell you how often people sit and they look at our flow charts. Our estate plans use a flow chart system, which is really great. It shows the numbers, and people say, well, wait a minute, that's not what I want. That's what I wanted last year, but I don't want to do that this year. It could be as simple as I paid for my daughter's wedding or help buy the house, and now I want to adjust that sum of money that's coming that would be paid out. So there are things you want to look at. And so Bryan, I appreciate this is a really great discussion. I appreciate it.
Good. I'm glad you enjoyed it.
Yeah.
I did as well.
And I think everybody got a lot out of it. So do you want to share? Do you have a screen that shares your contact information that you want to put up?
Did. When everything froze, I'm not going to go back to it. I'm worried it's going to flip it back, but I'm going to give everyone my email address and my phone number. So I'll count to 3, give you a chance to get your pen. 1, 2, 3. My email address is just my first name, Bryan, @rothkofflaw.com. And that's spelled ROTHKOFFLAW.com. And feel free to call me at the office. That number is 215-546-5800.
Talk about your office locations.
Sure. So we have 3 offices in Pennsylvania and 3 in New Jersey. We are in Lower Bucks at the Neshaminy Interplex in Trevose. We have an office in Center City at 15th and Market, and in Radnor, just off of 476 at the Radnor Financial Center. And we have 3 in New Jersey in Hamilton, Cherry Hill, and Turnersville.
Yeah, that's really convenient. And do you work in other states outside of Pennsylvania and New Jersey?
No, my partner and I are in a constant argument about who's going to get licensed in Florida. So sometime between now and the apocalypse, one of us will be licensed in Florida, fingers crossed. But fortunately, because the National Elder Law Bar is very collegial and we have a lot of national conferences, I have colleagues in almost all 50 states that I trust implicitly. So if anybody does need a recommendation for a loved one in another state, shoot me an email. I'm happy to make an introduction.
Now, do you consult with that attorney, with the folks, or you just hand it off?
Depends what they're looking for. If it's, you've got your parents live in California and you just need a recommendation, I'll do it that way. There's a family I'm working with right now. Dad moved up here and died very shortly after he moved up here, and he was a resident of Florida. So I'm sort of working as the family's liaison with their Florida-based attorney in Orlando. So that way they know they have me working with them. So it's, could be either side of the spectrum or somewhere in the middle.
Okay, great. All right, I don't see any other questions. I'm just going to remind everybody that we have our weekly webinars Tuesday mornings at 10 o'clock. We've got one more class of this advanced class series this same time next week, Wednesday at 6:30, and we're going to do a deeper dive into tax efficient planning strategies. So how to shift those funds from forever taxed to never taxed, as my mentor Ed Slott likes to say. Want to thank everybody. When you log off, you're going to have the opportunity to see my calendar if you want to book some time. And if you didn't get Bryan's email and phone numbers, just send me an email and I'll make sure I send you his contact info. Bryan, that was excellent. Thank you.
Thanks again, everybody. Have a good night.
All right, good night, buddy. Thanks. Take care. Hello again. I hope you enjoyed the video and perhaps you learned something new that can help you. If you want to schedule time for me for a no cost, no obligation consultation, you can use the link in the description and schedule a time that works best for you. If my schedule is full and you can't find anything, don't worry. Send us an email and we'll find a time that works for you. I look forward to speaking with you soon. Thank you. Have a great day.